The roots of racism in the United States pass straight through the U.S. Supreme Court. Check it out, leave your comments, ding the bell, share it with your friends, and subscribe to our channel. You know, in the context of the George Floyd murder trial of Derek Chauvin, and so much else that's going on, the hysteria around brown people coming across our southern border, you know, et cetera, et cetera. I think it's important that we have reasonable, thoughtful, and meaningful, deep conversations about where this racism came from in American society, beyond just the you know, kind of throwaway line of, oh yeah, well, we had slavery, you know, which is obviously a major piece of this, but it just seems to derail larger and deeper conversations sometimes about what do we do right now, and how did we get here, and what about things like Plessy v. Ferguson, and you know, where are we at under law? And so anyhow, on the line with us is Professor John A. Powell. He's a professor of law, as well as a professor of African American Studies and Ethnic Studies, the Robert D. Haas Chancellor's Chair in Equity and Inclusion, and the director of the Othering and Belonging Institute at UC Berkeley Law School. He's also the author of numerous books, including Racing to Justice, Transforming Our Concepts of Self and Others to Build an Inclusive Society. Law.berkeley.edu is his website, and you can tweet him at Prof. John Powell, spelled just the way it sounds. Professor Powell, welcome to the program. If we could start out, how do you define systemic racism in the United States? What's the context of the Chauvin? How do we put the Chauvin trial in that context?
Well, thank you, Thomas. It's great to be on your show. Well, there's a lot of things. So one way of thinking about systems, as just as the word suggests, there are things in relationship to each other. So, for example, you think of a school system, it's not just a teacher, it's also the principal, it's also the building, it's also the curriculum, it's also the tax system, it's also the students, it's all those things interacting with each other. And so when you think about this trial, first of all, just the fact that there have been, unfortunately, a number of black and brown people killed by the police because they're black and brown. And but very seldom are the police actually charged, first of all, let alone found guilty. Why is that? It's because it's the system. It's not just the individual police officer. He or she is trained, he or she is armed, he or she is sent out to the community. And more recently, since the 1980s, they oftentimes use military equipment. It's a system. And so it can't be fixed simply at one point. And now there's a trial. The trial is part of the system.
So
and many people in the community don't trust the system at all, so they don't trust the trial.
Yeah, I totally get that. So where do we start in... it seems to me like there's two pieces of this, or at least that I'd like to discuss with you. The first is, you know, how did we get here? Outside of the cliches, I know that you've written that a lot of this derives out of Plessy v. Ferguson, which had never occurred to me. I mean, you know, I know what it is and I know what its consequences were, but I don't understand the larger context. I'm not a scholar of this stuff. And secondly, what do we do about it?
So we have a new book out. It's a new article on Russell Say's, so I'll just say that, which the whole volume is devoted to Plessy. People will remember that Homer Plessy was what was called an octoroon. We don't use that term anymore, but it means he was 7/8 white. He phenotypically looked white. So one of the things, and this was in Louisiana, and Louisiana had passed a law saying that essentially blacks could not ride, or Negroes could not ride in boxcars with whites unless they were taking care of their children. And out of that came the doctrine of separate but equal, that blacks could get on trains, but they had to have their own car. They were separated, but they were equal. So Plessy did a number of things. It sort of cemented the already emerging Jim Crow laws and practices coming out of the South. And Jim Crow was in part a response to the Civil War, the Civil War amendments, and Lincoln's push to have blacks part of the society. I mean, that's what he was. That was his vision before he died, and that was the 13th and 14th and 15th Amendment. 15th being voting. And there was 12 years from 1865 to 1877, Reconstruction, that blacks were being elected, blacks were living all over. And then there was essentially an agreement to end that, where the Republicans, which was the good guys in the story, or gooder guys, I should say, they pulled out of the South, and in order to resolve a presidential election, they allowed the South to resubordinate blacks. And that was the start of Jim Crow and the end of Reconstruction. And then you had all kinds of laws and rules, and you had the rise of the Ku Klux Klan. And then in 1896, the Plessy versus Ferguson case came. Many of these things were already in place, but the court crystallized it by saying, despite the 13th, 14th, and 15th Amendment, 13th disrupting slavery, not totally ending it, 14th doing a number of things, advancing citizenship and equality, and the 15th advancing voting. So you had these three monumental shifts in our Constitution. Despite that, Plessy then says, well, equal doesn't mean that really equal. As long as so the states can separate groups as long as they provide equal provisions. And they never did. And it sort of just cemented the ability to actually create different worlds for blacks and whites. And it also allowed states to define who's black and white. Because Plessy was arguing that he was 7/8 white. He was arguing that he wasn't really black. He was an octoroon.
Right.
And the court said, no, it's up to each state to decide who's black and who's white. The construction, and that's what they did. And then you had things like the one-drop rule and all that. So it has a long history, a long tail. It's still not only distributing resources, but distributing identity.
Right. We're talking with Professor John Powell of the UC Berkeley Law School and the Professor of African American Studies and Ethnic Studies. Professor Powell, we have about a minute and a half before we're going to crash head on into a hard break where the machine is going to stop us. Where do we go from here? What do we do? I understood that in '54 Brown essentially overturned Plessy, but in all due time, right? Or if that was the phrase.
Yeah.
What do we do now?
Well, we have to keep working at it. So Brown said, yes, that Plessy essentially was wrong, but it also, there's Brown 1 and 2, but it also, so it said, this is a complicated system, it's deeply entrenched in the country. We can't change it all in one fell swoop. So there's Brown 2, which announced, let's make change, but let's do it in all deliberate speed, which means slowly.
Deliberate speed.
So it didn't, deliberate speed. And so nothing happened essentially for many years. And so the court was recognizing that this is a system, that it can't be changed in one fell swoop. But they also laid the foundation for not much change happening. We have to do better than that. Yes, things can be changed in one swoop, but they have to be changed. And it's not all deliberate speed. And policing is a big part of that. It's not the only part of it. Economics, housing, immigration, you talked about, all these things are part of it. And we have to really engage it. And like you said at the beginning of the program, we actually don't know this history or understand how we got here, which is part of how we get to where we need to be.
Yeah, well, you're doing an extraordinary job of filling it all in and educating people, and I know educating your students and with your writings. The journal here, hang on just a second, let me get that information. RussellSage.org is the Russell Sage Foundation, and the piece is Plessy v. Ferguson and the Legacy of Separate but Equal.